Nebraska gives landlords broad freedom to set and raise rent within a well-organized statutory framework. The governing law is found in Nebraska Revised Statutes, Chapter 76, Article 14, the state's adoption of the Uniform Residential Landlord and Tenant Act. And while it doesn't restrict the amount a landlord can charge, it establishes clear procedural requirements that must be followed. Nebraska does not have rent control or rent stabilization of any kind. There is no state statute that caps rent increases, limits the frequency of increases, or requires landlords to obtain government approval before raising rent. Nebraska's political and regulatory environment favors market-based pricing, and rent control has not gained significant legislative traction. Nebraska has not enacted a specific preemption statute prohibiting local rent control. But no Nebraska municipality has enacted or seriously considered local rent restrictions. Omaha, Lincoln, Bellevue, Grand Island, and every other Nebraska community operate under the same market-based framework. Given the state's political climate and relatively affordable housing market, local rent control is extremely unlikely in the foreseeable future. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. Nebraska requires at least 30 days written notice before the next periodic rental date for changes to the terms of a monthly tenancy. So if rent is due on the 1st and you want the increase to take effect on May 1st, you need to deliver the notice by April 1st at the latest. The notice should be in writing, should clearly state the current rent, the new rent amount, and the effective date. Nebraska doesn't prescribe a specific statutory form for rent increase notices, but the notice should be delivered by one of the methods authorized by statute. Personal delivery, leaving a copy at the tenant's usual place of residence, or sending by mail. Using a documented delivery method protects both parties and creates a record if a dispute arises. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing midterm increases. Common midterm adjustment provisions include escalation clauses, clauses tied to property tax changes, and CPI-based formulas. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent as part of a renewal or new lease. When a fixed-term lease is approaching expiration, the landlord should communicate the proposed new rent well in advance. If the tenant agrees to the new rate, a new lease or renewal is executed. If the tenant doesn't agree, the lease expires at its natural end. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the 30-day notice requirement for future changes. For week-to-week tenancies, the notice period for rent changes follows the one rental period rule, 7 days notice before the end of the weekly term. Now let's cover the restrictions that apply even without rent control. Rent increases cannot be retaliatory. Nebraska has one of the stronger anti-retaliation statutes in the Midwest. Under Section 76-1439, landlords cannot raise rent in retaliation for a tenant exercising any right under the Uniform Residential Landlord and Tenant Act. Protected activities include making a good faith complaint about habitability to the landlord or a government agency, reporting a code violation, exercising any right under the Landlord-Tenant Act, participating in a tenants organization, and complaining to the landlord about conditions that violate the rental agreement. Nebraska's anti-retaliation provision creates a rebuttable presumption of retaliation if the landlord takes adverse action within 1 year of the tenant's protected activity. 1 year is one of the longest presumption periods in the entire country. Most states use 6 months or less. This means that any rent increase delivered within 12 months of a tenant's complaint carries an automatic inference of retaliatory motive. The landlord must then demonstrate that the increase was motivated by legitimate business reasons, market conditions, operating cost changes, or property improvements, rather than by the tenant's protected activity. The consequences of a retaliatory rent increase in Nebraska are significant. The tenant can recover actual damages and reasonable attorney's fees. The finding can also undermine the landlord's credibility in any related proceedings. Given Nebraska's one-year presumption period, landlords need to be particularly thoughtful about the timing of rent increases relative to tenant complaints. If a tenant filed a habitability complaint 6 months ago and you're now raising rent, you need strong documentation showing that the increase was planned independently and is consistent with increases applied to other comparable units. Without that documentation, the presumption of retaliation may be difficult to overcome. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Nebraska Fair Housing Act, found in Nebraska Revised Statutes sections 20-301 through 20-344, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, or familial status. The Nebraska Equal Opportunity Commission investigates fair housing complaints and can take enforcement action, including ordering damages, injunctive relief, and civil penalties. Some Nebraska cities have enacted local anti-discrimination ordinances that provide broader protections than state law. Omaha and Lincoln both have local ordinances that include additional protected categories, such as sexual orientation and gender identity, that aren't covered by the State Fair Housing Act. Landlords in these cities must comply with both state and local anti-discrimination requirements when implementing rent increases. From a practical standpoint, Nebraska's rental market is anchored by 2 metropolitan areas, Omaha and Lincoln, with distinct secondary markets across the state. Omaha is by far the state's largest rental market and has experienced steady growth driven by a diversified economy. The city is home to several Fortune 500 companies, including Berkshire Hathaway, Union Pacific, Mutual of Omaha, and ConAgra, along with a strong healthcare sector, the University of Nebraska Medical Center, and Offutt Air Force Base. Omaha's rental market has been consistently solid, with moderate annual rent increases reflecting the city's economic stability and population growth. Omaha's different neighborhoods offer a range of rental price points. The Dundee, Benson, and Midtown areas have seen revitalization and strong demand from young professionals. West Omaha attracts families and offers newer construction at higher price points. North and South Omaha offer more affordable options, but with different demand dynamics. Understanding neighborhood-level conditions is important for setting appropriate rent levels and timing increases. Offutt Air Force Base, home to U.S. Strategic Command, brings a significant military population to the Bellevue and Papillion areas south of Omaha. Military tenants' housing budgets are tied to BAH rates, and landlords near the base should monitor annual BAH adjustments when planning rent increases. Pricing above the BAH rate can make units less competitive for service members. Lincoln, the state capital and home to the University of Nebraska, has a rental market driven by state government, the university, and a growing technology and manufacturing sector. The student housing market near UNL follows the academic calendar, with rent adjustments typically occurring at the beginning of each new lease cycle. The broader Lincoln market is stable and growing, with moderate pricing power for landlords. Lincoln's Haymarket District and downtown area have seen significant revitalization, creating strong demand for urban rental housing. South Lincoln and the areas near the university campus have different dynamics driven by student demand and proximity to campus amenities. Grand Island, Kearney, and other mid-sized Nebraska cities have rental markets influenced by regional employers, agriculture-related businesses, and local institutions. These markets are smaller and more sensitive to economic changes than Omaha or Lincoln, and landlords should be conservative about rent increases in communities where tenants have more options. Nebraska's agricultural economy influences rental markets in farming communities across the state. During strong commodity price cycles, farm workers and operators may seek housing in small towns, temporarily increasing demand. During weak cycles, demand softens. Landlords in agricultural communities should consider commodity market conditions when making pricing decisions. One best practice for Nebraska landlords, given the state's one-year anti-retaliation presumption, establish a consistent annual schedule for rent increases across all your properties. If you implement increases at the same time each year, such as at lease renewal or on a specific calendar date, the pattern demonstrates that increases are routine business decisions rather than reactions to any individual tenant's behavior. This consistency is your strongest protection against retaliation claims. Another best practice: include clear rent increase provisions in your fixed-term leases. A clause that specifies how rent will be adjusted at renewal, whether by a fixed percentage, a CPI-based formula, or a market rate adjustment with a specified notice period, sets expectations from the beginning and reduces the chance of disputes. Nebraska courts enforce lease terms as written, so a clear provision gives both parties certainty. For landlords in Nebraska's college towns, understanding the student rental market cycle is essential. Student housing typically turns over annually, giving landlords a natural opportunity to adjust rent. However, competition among student housing providers can be intense, and pricing must reflect the local competitive landscape. University enrollment trends, new student housing construction, and changes to university housing policies can all affect demand and pricing power. Nebraska's manufactured home park market is subject to additional requirements under the Nebraska Mobile Home Landlord and Tenant Act, found in Chapter 76, Article 14, Part 4. Landlords who own or manage manufactured home communities must follow specific notice and procedural requirements for lot rent increases that differ from standard residential tenancies. For Nebraska landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. Submit increase requests well in advance of the desired effective date. Nebraska requires landlords to return the security deposit within 14 days of the tenant vacating and providing a forwarding address. Nebraska's 14-day window is one of the shortest in the country, and landlords need to act promptly after the tenant moves out. While this doesn't directly regulate rent increases, landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant without a new agreement. For the complete guide to Nebraska rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our landlord-tenant law series.